We'll call the case of CANO versus CANO. Good morning, sir.
Good morning, Your Honor. My name is Michael Hines. I represent Mr. CANO, the appellant in this case. The calendar has a former associate of mine, Robin Compton, who went back to the State Attorney's Office as the counsel of record. I filed a corrected motion of notice of appearance, and I am the counsel who has been involved in the case from the very beginning. We're here today because we find that as we have appealed, we find that Judge Alexander's entry of a final judgment of injunction back in December of 2005 was an abuse of discretion. When you look at Judge Alexander's final judgment, he states, and he makes findings, specific findings that are contained on page 89 of the record, that after the hearing, the testimony of each party represented any witnesses upon consent, based on specific facts of this case, petitioner is a victim of domestic violence or has reasonable cause. And then the court goes on to say the court finds that bona fide acts, as in plural, of domestic violence occurred between the petitioner and the respondent. The petitioner struck, and I believe that the court has made an error in this, that the petitioner struck the respondent in the face on July 20th while holding the party's 3-month-old child. We believe that this is an abuse of discretion because all of the witnesses that testified in this particular case, the appellant in this case, the appellee in this case, a witness neighbor, Amanda Valencia, Tanya Itaragia, who was testified by deposition was a friend, and David Masters, all testified that my client struck the alleged victim in this case. There's actually no dispute to that. What the dispute ends up becoming is whether or not my client struck the alleged victim in response to her hitting him first. I know there's some contention in the appellee's brief, reply brief, as to the nature of the strike. The court finds in its finding very.
The petitioner testified at the hearing that he was threatening her, he was coming at her, he was berating her, yelling at her, and she pushed him away and he struck her. That was the testimony at the hearing.
That was the testimony of the hearing, but you also heard or read in the record.
Isn't that evidence? I mean, if the court believed that testimony and did not believe the other witnesses, and we aren't there, we can't make that credibility determination. Yes, I mean, isn't that sufficient to show a battery, a touching or striking against the petitioner's will?
I don't believe it is, because when a court finds, and the statute defines that the court has to find that she's a bona fide victim of domestic violence, and then it goes on to define all these crimes.
Battery being
one of them. And when you look at the definition of battery is actually and intentionally touching or striking a person of another. And the court never found this. I mean, the court did find that she was a bona fide victim, but the court never analyzed whether or not this was an intentional touching, because we heard testimony that the alleged victim that you just stated told her friend. I mean, these people don't have a dog in this, a fight in this show here. That she said, she being the victim.
Now you're talking about impeachment evidence. You're talking about the credibility of witnesses and that kind of thing, which is really.
Well, we're talking about whether or not there's competent, substantial evidence that a battery occurred, and that we have all of this evidence that was before the court, one of which was by deposition, that the petitioner, the alleged victim in this case, said, I hit him first. Now, we had one describing the punch, and I totally disagree in the appellee's reply brief that the court came to the conclusion there was no record evidence of the description of the punch, because there's just, I mean, there is testimony of how this hit her happened, but all of the witnesses testified, her incurrence, including the victim, that she hit him first. Whether it's a push or whether it's a punch, we have record testimony that all of the witnesses, including her friends, one a childhood friend, that she hit him or punched him first, and that my client, I know the court says that the court finds that at no time he claims self-defense. We don't agree with the contention by the trial court that at no time did we ever say, Your Honor, he was defending himself, that he was using enough force necessary to stop the... No, but it's clearly the evidence was that it was reflexive, it was in response to the hit that she admitted, all the witnesses admitted, including the father, that the battery occurred in defense of himself. So I think that there is...
So is it your argument that the testimony of the petitioner that she was struck while holding the 3-month-old child after your client was threatening her and coming at her and she simply pushed him away was insufficient to support the finding of fact because it's not believable in light of the other evidence? Or is your position that that evidence does not, even if believed, that would not be a battery?
Well, I believe it's, even if believed, it's not a battery. Because it is not, there is no finding that the battery was intentional, that there is nothing that has to be found, that the battery is not only actual but it was intentional, and there was absolutely no. I mean, we believe that when the court, if the court found that, I mean, I know. So
you're saying that your position is an injunction cannot be upheld unless the trial court writes out each element of the potential of the crime charge, like is a finding of fact, rather than just generally saying, I found that this person was a victim of domestic violence. Why isn't that enough? Why do they have to say, it was an assault, and I find that it happened like this and this and this, and each element of the crime was... I don't know that the statute requires that kind of specificity.
I understand Your Honor's concern about that, but when a court makes a blanket statement that is a bona fide victim of domestic violence, we don't know what the statute does list all of these statutes, and we can assume that he meant battery, but he doesn't make any specific findings as to, that this, what I think is important in this particular case.
Assume that if the trial judge finds that the petitioner was a victim of domestic violence, and our job is simply to determine whether there were facts in the record sufficient to support that finding.
Yes.
Is it your argument that there aren't sufficient facts to support the finding because there are other witnesses that contradict the petitioner's testimony?
Yes, there is.
Okay. So you're asking us to make this credibility determination between what
it does put me then, and I understand, but by asking me that, the courts have to give great deference to the trial court when there becomes matters of credibility. I understand and appreciate that the law stands for that, Your Honor. However, when you're looking, what makes in this particular case, what makes it so difficult is because the court then states at no time does he claim self-defense. So we have to say that the trial court put great weight on that the court was saying that if there was a claim of self-defense, then perhaps this wouldn't have been a battery. When I believe that there is competent substantial evidence in the file that he does make a claim of self-defense, and that claim of self-defense comes through to the victims, through the other witnesses in this case, who say that he hit in response to the victims. I believe that there is, and I understand and appreciate Your Honor's concern about the court. It would be kind of bizarre to have each trial court out there to say, all right, I find that it's a battery, and this is why I find it's a battery. But in this particular case, the court takes away a defense to a battery, which would be self-defense, and just kind of dispels it. And when there is, I believe, record evidence that the appellant in this case did claim self-defense. Additionally, one of the claims that the trial court, one of the findings of the trial court, he actually makes three findings. One that you and I have been discussing about the acts of domestic violence. Second, that the testimony of David Masters is that the petitioner was hit in the face, and I think that the evidence is clear that all witnesses testified that happened. Why the court has to say that furthermore, the testimony of the petitioner, there was no dispute that happened. And then finally, which is more concerning, is the excited utterance by the party's older child, and the record evidence is clear that it wasn't a child, it was a niece, or it wasn't their child, it was a niece, it was one of his grandchildren, but it wasn't their child, that the child grandfather requesting help from the Elkton home in September of 2004, and we believe that is an error in that it was September of 2005, is most compelling, as the court puts in, that the respondent concerned cornered the petitioner and bullied her in front of the children 2 months after slapping her in Miami on July 20th, 2000. And what this portion is going not only the trial judge ruled that the petitioner was a victim of domestic violence, but then goes on, I believe, in this paragraph to show why she was in reasonable fear of domestic violence or impending domestic violence. And when you look at this, if you look at the record, it was clear that I objected to the hearsay evidence, that opposing counsel in this particular case was put on notice by the judge. I sustained my objection. You haven't laid the predicate. A couple more questions were asked, and the proper predicate, the court didn't conduct the proper inquiry as to whether or not this utterance, that it's double hearsay. It's the one Mr. Masters was saying about what a juvenile child has said, that there's no findings of whether or not this was immediately happening, during, or anything. The courts did not make those specific findings, and then comes in the final judgment and says that it finds that it was an exciting utterance. It's our position that the court couldn't find that based on the record evidence. What is interesting about the case is that this alleged battery, when you're looking at the statute and you're looking at whether or not she's in reasonable fear, this alleged battery happened on July 20th, 2005.
The testimony was that the niece came running out to the grandfather. Yes. Well, the niece of one party, the grandchild to the grandfather, came running out, highly upset and agitated, and said they're fighting inside. And you don't think that that's a sufficient predicate to show an excited utterance?
Well, it's not only that, but it's double hearsay. I mean, it's hearsay within hearsay.
You don't think that that's sufficient to show an excited utterance? A child runs out, highly upset. You have to come right now. They're fighting inside.
Or words. We don't know exactly what she said. And
that seems to be the gist of, from my review of the record.
But what makes it even more interesting is that even the testimony of the parties are that they were. I mean, what is fighting? Fighting, is it physical? Is it arguing? In excited utterance of what? That they're having an argument? I mean, that was clear from the record from both parties that they were having an argument. But that argument doesn't lead to domestic violence or reasonable fear of domestic violence. In fact, I think the record evidence proves the complete opposite. This first alleged battery happened on July 20th, 2005. You have testimony that there were numerous visits because the parties separated. They filed a divorce the divorce has been filed down in Miami. She comes up to St. Augustine and eventually files for a domestic violence injunction. That on July 20th, this first alleged battery, we have visitation in July. We have visitation in August. We have visitation through September. In fact, this was during one of the visitations. We have visitation where the petitioner came from from St. Augustine, went down to Miami. There was visitation down there. We heard record testimony. There was an argument about my client filing for divorce down in Miami, and it was not, and she still did not file for an injunction. It wasn't until October 11th, 2005, after numerous, Your Honor, seeing the record evidence of how many visits there were, how can she claim that she was in reasonable fear of future domestic violence when you have all of this contact going on back and forth between the parties? And it wasn't until he claims that he's going to file for divorce that she claims that she goes and gets a domestic violence injunction. I think it's clear that the domestic violence injunction was used in order to garner favor or to get a position in a divorce case. But having said that, Your Honor has to decide whether or not the court, in this particular case, there is competent, substantial record evidence that A, that there was a victim, that she was a victim of domestic violence, and B, whether or not she was in reasonable fear. And as our brief is, we have in our brief, it's our position that she has not. And I will reserve the rest of my time for rebuttal.
Thank you, counsel.
May it please the Court. Good morning. My name is Maureen Sullivan-Christini, and I represent Therese CANO. The ruling of the trial court should be affirmed by this panel. There was sufficient competent evidence to show that Therese CANO was a victim of domestic violence. Now, that evidence came about through her testimony, through the testimony of her father, through the appellant's testimony, and 2 other witnesses. Now, we know, and I'm sure it's not news to you, that Judge Alexander's ruling comes to you cloaked in the presumption of correctness. And the way I look at this case, and I think the way that I wrote my brief, the order that Judge Alexander entered was based strictly on credibility of the witness. That he gauged it in terms of credibility, and opposing counsel has read this order to you at least on 2 occasions, but it's credibility, credibility, and credibility. And of course, as this panel knows, credibility is not a call for an appellate court. Credibility is a call for a trial court. And appellate courts must place great deference on issues of credibility and fact that are made by trial courts. So I think that what the opposing counsel is saying is we've impeached the petitioner, so therefore she can't be credible and you need to reverse Judge Alexander's ruling, which I don't believe is accurate. I don't believe it's correct, and I don't believe if it's strictly based on credibility that this court should do so. Now, addressing some of the points made by opposing counsel, the petitioner or the appellant stated that she pushed him to get away from her because she was afraid he was crowding her, he was getting in her space, he was getting in her face. And then he slapped her hard across the head and across the face. And she started crying. And she went in the corner and she prayed and she asked for mercy, and she stayed there because she was afraid of what he did. And then, as the record supports, she apologized to appease him. And she left. She went, she called her father, her family. I believe she also, there's some testimony in the transcript that says that she went to a priest, and the priest told her to make a police report, and then she went and stayed with her brother, and then she came all the way up to Elkton, which is north of St. Augustine, from Miami. And I submit that she did those things out of fear. Now, this whole, what we heard from opposing counsel about this happened because she learned that he was going to file a divorce. Well, if you look at the transcript, she testified that she knew on June 30th that he was going to file for divorce. In fact, the appellant himself testified at the hearing that he moved out of the house in June because he was going to get a divorce, and then he moved back in, not to reconcile, but to work out problems. That's his testimony, his words. So the theory put forth by opposing counsel doesn't wash, doesn't fly, whatever metaphor is appropriate. Now, with regards to, and just one thing, if you look at the transcript, I'm not sure what page number it is, Mr. Masters, the testimony of Mr. Masters, who Judge Alexander found to be most credible. Mr. Masters testified that his 7-year-old grandchild came out to get him from the garage where he was working on a car. He didn't say which grandchild. For what the record reflects, it could be the appellant and appellee's child. And I think that's an important point. And with regards to the whole excited utterance issue, I believe that the Judge Alexander made a lawful ruling that there was a proper predicate laid, and that Mr. Masters' testimony, I believe, was most credible to Judge Alexander, not because necessarily the excited utterance, but because Mr. Masters is my client, the appellee's father. And throughout the trial, when he testified initially he didn't want him to get divorced. He didn't want there to be a domestic violence injunction. In fact, he called the appellant and said, you know what, my daughter's got an injunction against you, and if you come up here, the sheriff's going to be looking for you. Just serve him with it. And the reason I believe that the judge found that testimony credible, because he was even-handed and fair, and in his testimony had many of the hallmarks of credibility. Now, let me collect a few more thoughts here. Now, also, appellant states that the court was incorrect, that there was not an act of domestic violence because his client was acting reflexively, and states that he's reflexive. The reflectiveness was to her pushing him. Well, contrarily, the reflectiveness could be to the wife saying, stay away from me, I don't want you around. Bam. Because there is testimony in the transcript that he uses an expletive, and I believe my client testified that he called her a bitch, if I'm not mistaken, when he slapped her across the face. That all has the hallmarks of domestic violence. And finally, the St. Johns County incident, where she's letting him visit the kids, but he visits the kids when her family is home, when there's somebody there, because she's afraid to be alone. And throughout the entire transcript, she is afraid to be alone with the appellant. And the final episode, on September 25th of 2005, they're in the house. The mother lets him stay there. He comes up all the time. She wants him to see his kids. She wants him to have a relationship with his kids. And he starts yelling at her and berating her. And what does she do? She goes and hides in the closet in her room. And she's in her room crying in the closet to get away from the appellant. And then her kids, her one child and her niece and another child come in, and they're in there trying to get her out of the closet. And then what happens? The appellant comes in when she's in the closet hiding, and he walks back out, and he starts berating her again and berating his daughter. So the appellee gets out of the closet, takes her daughter away from him, and goes into another room, and the appellant follows her, berating her the entire time, which leads to one of the grandchildren going out to the garage and getting Mr. Masters to come into the house. And what does Mr. Masters say when he gets in the house? Well, they weren't doing anything, but I know Therese was upset. She'd been crying. She had red eyes. She was very subdued. And I could tell there was something going on. So I believe that Judge Alexander's ruling and his order is correct, because what would have happened if they had not been at the Masters' home? That put the appellee in a position to think or to believe that she will be struck again and again if they ever do have arguments and things of that nature. I think I've addressed everything that that I can, especially when it is my belief that this is purely a question of credibility of the witnesses. It's truly a question of credibility of the witnesses. And I don't have anything further to say. Thank you very much.
Thank you, ma'am.
Very briefly, when opposing counsel asked the question, what would have happened had they not been at the, I think it's irrelevant. I mean, what we do know that happened on the 25th, and I submit to you that there was, when you look at I believe it's the Galarza opinion that we cited in our Galanza opinion, that although the berating may offend people, that this was happening, this clearly was not an act of domestic violence that happened during this, I'm talking about the 25th incident when the children were involved. This is merely an argument that was happening. And when opposing counsel says what would have happened, I think it's irrelevant what would have happened. It didn't happen, hadn't happened during the numerous visits that happened in between the July incident and the September 25th incident. And when you look at, and I understand that it's our burden when we're looking at credibility, that we're supposed to give great deference, but the courts have to look at whether or not there is substantial competent evidence for the court that had made the decision that it had. And we believe that when you look at the testimony that the court does not have, particularly because the court finds, as I've argued before, at no time does he claim self-defense, that the court finds particular value to that. And when a court talks about what the grandfather said, and it says this is most compelling of what? I mean, it's most compelling that they had an argument at the residence on the 25th. That is not an act of domestic violence, and shouldn't be held to such. And it's not, when you look at the Galarza and other opinions, when you're looking at what is evidence of someone being in reasonable fear of their safety and of imminent domestic violence, that it doesn't reach the standard. And we ask that you overturn the court's decision in this case.
Thank you very much, counsel.